Hello, Tripta Dixit ma'am. Hello, is my voice is clear to you? I'm audible to you, ma'am. Ma'am, your voice is not clear at all to us. Uh, Hello.
Sir, voice is not clear.
Hello. Hello. Ah, no,
Hello,
so
Dr. Ravi.
ah,
Hello.
nalan nagkamukha. Mga exercises post office যাওয়ার ছিল আমরা তো চলে আমার তো অর্জেন্ট
Dr. Ravi.
तो बोला भैया
Yes, sir.
हमको लेके आई इतनी मुश्किल
Uh,
से
is there any change in the schedule? Because I think, and this, she is not replying to us because we are not able to listen, Tripta ma'am.
Yes, sir.
So, and we are not getting any updates in that. Do you have any contact number?
I don't have contact number, sir. I think Saula sir is trying to connect.
Okay. Good afternoon, sir. Vinit, sir.
भरत गुड आफ्टरनून यार वो
हाँ, good afternoon, sir.
मैडम को ज्वाइन करवाना एक मिनट
Okay, sorry.
डॉक्टर शैलेश
सर
वो मुझे मैसेज करो आपने क्या ईमेल डाल रखे हैं उसमें
सर वो
प्रोजेक्ट मैनेजर और सीनियर प्रोजेक्ट ऑफिसर
सर तीनों को गया है
मुझे मैसेज करो एग्जैक्ट ईमेल क्या भरे हैं आपने वो मुझे मैसेज करो
मैं करता हूँ हाँ
डॉक्टर शैलेश रवि
सर
रीमा मैडम ने ज्वाइन किया है बट उनका लिंक पता नहीं क्या है वो अटेंडी वाला चला गया है तो
अच्छा मैं ढूंढ लेता हूँ सर एक मिनट
REE
हाँ आ गया सर रीमा मेहदी आ गया सर मैं पैनलिस्ट बना दिया
उनको वो प्रेजेंटेशन दे दो
हाँ मैं दे देता हूँ
उसमें उनको सर्च करो प्रगति को सर्च करो
हाँ मैं करता हूँ
बट मैडम प्रगति का तो आ रहा है कि ईमेल ही मैच नहीं कर रही है आप प्रगति मैडम के लिए मेल भेज दो मेरे को क्या है सीनियर प्रोजेक्ट ऑफिसर जो भी मेल है ना वो मेल टाइप
हाँ
करके भेज दो
मैं भेजता हूँ
मैडम का शुरू कराते हैं
हाँ
डॉक्टर
ठीक
भरत गुड आफ्टरनून आप गुड आफ्टरनून भरत
हाँ, good afternoon, sir.
मैडम भी हैं और मीरा मैडम भी हैं Septa madam,
So
very
the
good
first
afternoon and good welcome, very welcome, warm welcome. And Madam Rima, madam, a very welcome, warm welcome to both of you.
Yeah, good afternoon, sir.
I have my co-host from NIT Patna, Dr. Bharat Gupta.
Hello, good afternoon.
Yeah, good afternoon.
And I have my colleague here, Dr. Ravi Madila, who is actually coordinating the assist program. Dr. Madila.
Good afternoon, ma'am.
मैडम आप जब भी तैयार हो तो आप बता दें
Yes, I'm ready. I'm actually, I have been given the rights of sharing my screen. So I'm just sharing my screen.
Sure, madam, please. Ravi.
So, sir.
Just let me know if my screen is visible to everyone.
Yes, ma'am, your screen is visible.
It is visible.
Please
Okay.
Presentation mode, yeah.
Thank you so much, everyone. A very warm welcome and good afternoon to everyone.
Ma'am, I please allow me to just introduce you here in front of the audience with your permission.
Yes, please. Thank you.
Sorry to interrupt in this. Okay. Very good afternoon to all the participants, all the experts and CIs and the academic level coordinator and all the proctor coordinators. I welcome you all on the 7th day of this program on digital tools for writing, authoring, and reviewing script. Today, this is the first session, which is going to be taken by Miss Rima Sahini Mediratta. And she is going to talk on the introduction of intellectual property rights. And yes, she will talk about this. I just say Ms. Sahani is working as a project manager, IP and tech transfer at Innovation Technology Transfer Office. She is a registered patent agent with Indian Patent Office and has experience of more than 7 years in the domain of intellectual property. As a part of the IP team, she is actively involved in formulating IP strategies of the client inventions and advising many SMEs, startups, and individuals on securing, protect, and enforcing IP rights in. She will different forms of the intellectual properties. So with this introduction, I will like to welcome ma'am on this FDP. And ma'am, thank you for accepting our invitation and be with us on this day. Thank you, ma'am. And now it's over to you.
Yeah, thank you so much for the warm welcome and very wonderful introduction. So I'm Rima Sani Medirata, Project Manager ITTO, FITT, and today I'm going to present Introduction to Intellectual Property Rights. So what is IP? When you think out of the box, generate ideas and own them, it is called IPR, Intellectual Property Rights. So these are the different forms of intellectual property. It can be any patented drug, trademark, copyright, industrial design, trade secret, GIs, layout design, etc. Now come to the next slide. What is the nature of intellectual property? Intellectual property is basically creation of mind. It is our intellect. Like other properties, it is intangible in nature. We can't touch them. IP rights are always exclusive right in nature because the creator or the inventor of these rights has the exclusive right to use them, sell them, or give it to others. IP rights are always territorial in nature. Means if you have filed IP in India itself, then you can join your rights only in India. And if you want to enjoy in other countries, then you have to protect in other countries as well. IP rights are always called negative rights because you are stopping others from using your rights. IP rights are time-bound rights. There is a limited period of time for which the IP rights are granted or by IPO, Indian Patent Office or Trademark Industry. IP rights are legally enforceable as well. If anybody is copying your idea, then you can take legal action against them. So what are the benefits of filing IP for any academic institution? So filing IP, it is a new way for academia to disseminate its knowledge and create solution for the society. In the outbreak of COVID-19, we all have noticed that so many academic institutions, they invented mask, PPE kits, and diagnostic kit. So this is like add-on to the good of society. So IP, it does not only help. Am I audible to you? Hello?
Yes, ma'am, you are audible.
Okay. So it is an asset for an academic institution and it helps in brand value of academic institution as well. I can explain this with an example. If any student he wants to take admission in any academic institution, then what is the first thing he will take? Okay, the ranking of academic institution. And IP portfolio is one of the factor, one of the parameter of giving any ranking to any academic institution. So indirectly, IP filing or IP is an asset for a academic institute and it helps in building brand value for that institution. It promotes innovation, collaboration, and student entrepreneurship. So it is new way for generation of revenue for the faculty or the students as well. New career opportunity for faculty, staff, and students, and new sources of revenue. So it acts as motivator factor for any academic institution as well, because according to the IP policy of that academic institution, students, faculty, and the academic institute will get some part of the revenue. IP and tech transfer, it promotes university or academic spin-off as well. What is spin-off? Spin-off is any business venture which is started by a student or faculty of any academic institution, and from which business venture the student or faculty, they earn revenue as well. What are the drawbacks of not protecting your IP? The first one is, if you will not protect your IP, then anyone can copy your idea. For example, if you have created something and you discuss with any company or any collaborator for further development of your technology and you have not signed NDA with those collaborators or big company, then they can steal your idea and improvise that and file IP at their own name. And you can't take any legal action against them because you have not filed any IP, you have not signed any NDA. So there is no any evidence for the same. And indirectly, you will create competition for yourself as well because they will start manufacturing your technology and sell them in market as well. So it is always recommended to file IP before discussing your idea with anyone. What are the types of intellectual property? As discussed in my previous slides, IP can be patent, trademark, copyright, industrial design, traditional knowledge, layout circuit, etc. Now we will discuss about each IP. So first I will discuss about patents. What are patents? Patents, these are the exclusive rights which are given by the government when you disclose your invention, your idea in front of government. So patent rights are given for product as well as for process. There is a limited time period of tenure of any IP. Likewise in a patent, these are granted for 20 years and time period is counted from first filing of patent application. IP rights are territorial in nature. For example, if you have filed patent application in India, then you can protect your IP in India and nobody can copy your idea in India, but you want to protect or stop anyone in copying your idea in US, but you will be able to stop others from copying your idea in case if you have filed patent application in US itself. So IP rights are always territorial rights in nature. IP rights are called negative rights. Why? Because you are stopping others from copying your ideas. You are stopping anyone from using your patent application and what is disclosed in that application. And patent rights, they can be sold, licensed, mortgaged, inherited, and transferred as well. What are the rights which are given to a patentee? Right to manufacture and use the invention, and patentee has right to sell the patented invention, and patentee can prevent others from importing the patented invention where there is a IP protection. So what is the purpose of patent? Why every researcher is excited about filing patent application for their invention, their work? So it is like a motivating factor for the researcher. It adds incentive to the inventor. It encourages research and development in the country as well. It brings the technology to the market. It promotes transfer of technology. It promotes commercial exploitation of technology at its fullest. For example, if you have spent so much time, your intellect and money on your research work, so you wanted to protect and in future you want the revenue from your invention because you have spent so much on that, and of course your invention, your idea had worth of filing patent application as well. So what is the patentability criteria for any invention? There are 4 patentability criteria. First one is novelty, second is non-obvious inventive step, third is industrial application, and fourth is patentable subject matter. Now first we will discuss about novelty. It is always said there is nothing like global patent. So if you for example, it is always said that only the one publication can kill the novelty of your invention. If you want to file any patent application, then it should be novel, means it should not be in public domain. If it is not novel, then and you file patent application, then patent office will reject your application. They will cite the prior art in your application. Second is your patent application. Your idea should have inventive step. Means it should not be obvious to the person who are skilled in that art, and your invention should have a technical advancement than the already existed technology in public domain. Third is industrial application. Industrial application means if you have invented something and there is no use of your invention, then the same application will be objected by the IPO, because industrial application means utility is the third criteria for patentability. Fourth, patentable subject matter. Your invention should not lie under the patent section 3 and 4 of Indian Patent Act. So I will discuss about few important subsection of section 3. Section 3, it relates to non-patentable subject matter. So according to subsection A of section 3, any invention which is frivolous in nature, means which is contrary to the well-established natural law, is not at all patentable. For example, there is nothing like perpetual machine. For running of any machine input, the fuel is required. So if anybody claims that this is a perpetual machine and I want to file patent application for that, so this is frivolous invention. So it is not patentable subject matter. Subsection B of section 3, any invention which is contrary to the public order or morality and which cause serious prejudice to the human health is not at all patentable, or infect the animal as well. For example, any illegal drug, it is not patentable subject matter. According to subsection C of section 3, any discovery of scientific principle, for example, Einstein theory, Newton's law, Pythagoras theorem, these all the examples of discovery of scientific principle. So any invention which is based upon these scientific principle is not patentable subject matter. Section 3D of section 3, which is most important section for pharma companies as well, or it is a new form if your invention is new form of a known substance or it has a new property. So for any substance, process, machine or apparatus, then it is not patentable. For example, you have invented one medicine which is antipyretic in nature, okay, and means it was helpful for patient who has fever, and after some month you realize that its other property which is antibiotic in nature, then you can't file patent application for the second use of existing substance, because you have done nothing to increase the therapeutic efficacy of existing product. So it is not patentable. Section E, the mere admixture resulting in addition of property of known substance is not patentable. For example, you have mixed some proportionate of salt and any 2 or 3 salt and made a mixture. So it is not at all called any kind of invention. You are just mixing the 2 or 3 salts together. Subsection I of section 3, it states that method of treatment of human beings or method of treatment of animals, it is not patentable. So diagnostic method is not patentable, but the device diagnostic kit is patentable. And subsection J, plants and animals as a whole, they are not patentable, but any genetically modified microorganism, it is patentable, because you have the genetically modify animal, it will have the technical advancement and it will have some utility as well, and you invested your intellect in that microorganism. And 4 of Indian Patent Act, it said that any invention which is related to atomic energy is not patentable. So I just want to discuss a very good example of section 3D. in which the new use of known substance is not patentable. The first thing is that it does not promote the evergreening of product as well. And for the drugs, it is very important. It should be available to the general public at reasonable price as well. So this is the landmark judgment for case 3D. So everybody is familiar with the Novartis company, who is famous in having the anti-cancer drug Glyvic in India. Glyvic, it used to treat chronic myeloid leukemia and other type of cancer. But the problem was that they invented Glyvic from beta crystalline form of imatinib mesylate. Imatinib mesylate was already existing substance, and they have filed patent application for the same substance in other 35 countries as well. So they just have invented the second form of existing substance. So Supreme Court of India, they rejected this Glyvic drug in India, and these are the conclusion of their judgment. Because first point was that Novartis, they failed to prove that the therapeutic efficacy of beta crystalline form is better than the already existing substance. So this was the one issue. Because of that, Supreme Court objected the application, and the judgment given by Honorable Supreme Court is to prevent the evergreening of patented product by introducing minor changes. Why? To give relief to those who can't afford the life-saving drug at reasonable prices. And these big company, what they used to do, they used to sell life-saving drugs at a very high price. So Section 3D is very useful to stop these big company from selling the drugs on very high price, or indirectly to stop the evergreening of patented products. So this is the scenario at Indian patent filing system. So when you file in patent application in India, you can do two things. You can file directly provisional patent application or complete specification as well. If you think your invention is not complete and you want to protect your idea, then it is always advisable to file provisional application first, so that you can reserve your have your priority for the patent application. And after that, within 12 months time, you can file complete specification, and you will have enough amount of time in which you can further develop your technology as well. Then after 18 months of filing first application, your application will be published. And if you want to expedite the process, then you can request early publication as well, and file Form 9 for requesting IPO. And within 48 months from first filing, you have to file request for examination. It is mandatory for any applicant to file request for examination. If you will not file this request, then your application will not be examined by IPO and it will be abandoned. After filing request for examination, IPO will issue examination report, and within 6 months you have to reply to file response to the examination report. In ER examination report, IPO will cite prior arts or any other technical error if there is. If IPO examiner or controller is okay with your response to ER, then they will grant patent application. They will grant patent to you, and if not, then they will put your application for hearing, and in that hearing you can take all the evidence or all the reply to the objection by the IPO, and then if they will be convinced by your response, they will grant your application. Otherwise your application will be refused. And there is after publication of, there is opposition as well, pre-grant opposition and post-grant opposition. Pre-grant opposition is after publication of your application, and post-grant opposition is after publication of your granted patent. So this is all about Indian patent filing system. Now come to the types of patent application filings. So there are, first is ordinary patent application filing. It means in which you are not claiming any priority, is called ordinary patent application. And second is Paris Convention. So this is the oldest treaty for IP, and 177 countries are part of Paris Convention, whereas PCT is Patent Cooperation Treaty, and 153 countries are members to this treaty. So these both are, if you are interested to file your patent application in abroad, so these are these are the two routes from which you can file your patent application in abroad, through Paris Convention or PCT route. But the benefit of PCT, or it is advisable to file through PCT application if you are under the process of deciding in which country you want to go on the basis of market potential. Why? Because in Paris Convention, there is deadline of 12 months from the first filing. Whereas in case of PCT application, within 12 months, you have to file PCT application, but there is deadline of 30 to 31 months from the first filing in which you can decide about your national phase filing. National phase filing is the country in which you want to file your application. So there is a benefit of filing PCT application because in one language you can file your patent application in other countries as well. If you want to file in 4 or 5 countries, there is no need to file separate documents in the separate countries. So PCT serve this purpose and save your time and give you enough time to decide if you want to file patent application in other countries or not. For example, today you file patent application with Indian Patent Office, and after 12 months down the line, you file PCT application. But after few months, you realize that you decided to file patent application in US, Japan, China, and 2 more other countries. But after filing PCT application, you notice that now there is no any market potential of your technology in US. Then you can decide that as per market potential of your technology in US, if there is then there is no need to spend more money for filing patent application in US itself. So now come to the next example, which is very interesting, which tell us about how one person can, or any academic institution can become billionaire by filing patent application. Gatorade. This is the beverage name. So researcher at the University of Florida, they began to study why the school football players were being affected by the heat. They invented a new drink for athletes. So they named it as Gatorade. And after a few days, they sold it to a beverage company, Stockley Van Camp, in 1967. And company agreed to pay them $25,000 in addition to a small bonus, means some amount of royalty on every gallon sold. And from this royalty, 20% of which belong to the University of Florida. Maybe it is as per their IP policy. So as per ESPN report in October 2015, the royalty, it surpassed $1 billion. So from this example, you can see the significance of filing patent application. Basically, if you file any patent for your invention, maybe in future you can do the IP translation, means you can transfer your technology to any big company, to any startup, or you can start your own startup and take that technology from the academia and further develop the technology and start manufacturing. So this is the best way of generating revenue for any academic institution. Now the second example is inventors who did not get rich because they have not filed any patent application for their work. So Daisuke Inoue, he was the inventor of karaoke machine. Karaoke machine is basically the empty orchestra. So during the lockdown, I guess most of the people, they discovered their innate talent of singing. So that empty orchestra, which is available online in different app, is so the main inventor of empty orchestra is Daisuke Inoue. He was a Japanese businessman. He used to make money by playing drums in a backing band in a bar. And one time when he could not make a gig, he put empty orchestra. And later he made 11 karaoke machine, which he leased out later. But he did not file patent application for this invention. If he would have filed any patent application, then he, he must be billionaire this time. So this invention or the inventor story tell us about if you have any idea, any invention which you think has worth. So before publication of that invention or any idea, please file patent application for your invention. And after that, you can decide if you want to take it further at your own or to transfer it to the other companies. Humse Pucho. So this is an initiative of Innovation Technology Transfer Office. It is a web-based one-on-one session to answer your query related to patent and technology transfer. And it is this platform is open to faculty members, students, startup, and entrepreneur. You can visit our LinkedIn profile. You will get to know there is a post, Humse Pucho, and you can use that link and book your slot every Friday. And our expert IP professional and TT professional will answer your queries. Now come to the second IP, which is trademarks. John Stewart, chairman of Quaker, he once said, if this business were split up, I would give you the land and brick and mortar, and I would take the brands and trademark, and I would fare better than you. So statement by chairman of Quaker, it tells us how significant it is to have trademark for your business, because it is a brand value for your business. So any sign, any image which individualize your goods of a given enterprise and which distinguish your product from the competitor product is called the trademark. So I can give you very simple example. If you want to buy any phone, then if you see Apple, Samsung, and Android, you picked up Apple phone. Why? Because you know about the brand value of Apple and you know the quality of that phone that brand will promise to the customer. So trademark is basically one's identity in the market. You can relate brand with the quality of that product. Brand or trademark, it helps in building of brand value as well. For example, everyone is aware about McDonald's and Starbucks. So once they decided to launch their business in India, the first thing which they did was they protected their IP in India first. First of all, they filed trademark application, various trademark. They have multiple trademarks for different cuisine, for different for their name and product. So they first of all they protected their IP and then they launched their business. The term like other IP, trademark is also granted for a limited time of period. So the term of trademark is 10 years from first filing, and there is option of renewal of trademark as well. So it is always recommended for any startup, for any company, before starting or launching your business, first of all, protect your trademark, because in future, if you will be your business will be successful, you will be famous on the basis of your trademark itself. What can be trademark? Trademark can be word mark. For example, Coca-Cola is a word mark. It can be a logo, just like BMW logo or Apple logo. It can be combination of word mark and logo, just like McDonald inside of McDonald with the tagline, "I'm loving it." It can be any color mark. It can be for shape, packaging mark, and rarest example is sound and spell marks as well. Now we will discuss about the next IP, which is copyright. So what is the copyright? Copyright, it is a bundle of exclusive rights which are given to the creator of origin of that work. So means copyright is always granted to the person who created that work. And the most important thing and interesting as well about copyright is that copyright protection does not depend upon registration. For example, your PhD thesis, manuscript, it is not mandatory to file copyright for your PhD thesis. If you have created that work, then copyright rights are with you. Okay, for example, and the second thing is that copyright law protects ideas which are expressed in a tangible form. For example, in my mind, there is one rhyme or poem, but this is not the copyrightable subject matter until or unless I will write down that poem on copy pen and then the copyright of that poem, because I express my idea in tangible form. In that case, it will be eligible for copyrightable subject matter. There is very interesting example. For example, if any author of the work is an employee in a company, then the work which he made during the employment period, in that case, the owner of copyright will be the company. Why? Because employee was paid for that work. So this is the best example of copyright, not on idea, but expression of idea. So you know about these novels and Two States, 5 Point Someone, and Hamlet. This is already in public domain, but anyone can express that idea in any form, just like the movies which are based upon these novels, Three Idiots, Two States, Heather. But by giving copyright credit to the author of that book. You can express that idea, but yes, you can take permission from the author of that idea itself. Copyrightable subject matter. Any literary work, musical work, artistic work, sound recording, these all are copyrightable subject matter. And what are the rights which are given to any creator under copyright law? So right to reproduce, the person can make so many copies of their work. Right to distribute, they can distribute those copies amongst the public. They can adapt, they can make a different form of that work. They have right to public display as well. But no person who has no rights, they can't do that, otherwise it will be offensive, and the owner of copyright over that work can take legal action against that person. As I mentioned, it is not mandatory to file copyright application for your work. Yes, it is true, but if you but it is always recommendable that if you have created some work, then file copyright application. Why? Because in future, if somebody is copying your idea, then you can file or you can take action against that person itself. Now come to the next IP, which is industrial design. So this is also an interesting example because I can give you one example. If you have decided to buy a sofa set in a interior shop or any furniture shop, there were two sofa sets, sofa set A, sofa set B, and both are available on same price. But you bought sofa set A. Why? Because it was it was comfortable, and the most important was its design. It was very appealing, very attractive to the eyes. So its design is just like the value addition in an article. So product design input, it contributes 60% to its wealth generation, as well as influence 50% of the inbuilt quality of its value chain, and thereby contribute significantly to the competitiveness of that product. Because both sofa set A and sofa set B, both were available on same price and both were very comfortable. But I bought sofa set A because of its unique design, which was very appealing to my eyes. So it means industrial design, it plays very important role for any article for the customers. So industrial design, it protects designs that are applied to an article. If you have drawn some design on a paper, it is not the matter of industrial design until or unless you implemented that design on an article itself. Second is, it is one of the category of IPR where a design system, it focus on the outer feature of an article. Basically, aesthetic feature of an article, the ornamental or aesthetic aspect of an article, which enhances the visual appeal of that article. It can be granted for shape, configuration, surface pattern, the color line, or combination of colors which are applied to an article. And design can be two-dimensional or three-dimensional. And it is protected for 10 years from the date of registration, which can be extendable as well. It can be granted for device, or it can be a small apparatus or component of device as well. So these are example of industrial design. I can explain one example of iPod. Before the invention of iPod, people used to save songs on pen drive. So Apple, they launched the product iPod. So what was the difference between both the thing? It's a design, iPod's design, and its cost was 3 to 4 times than a pen drive, and it solves the same purpose as the pen drive is serving. But most of the people, they bought iPhone. Why? Because of its attractive design. So it tells us about the importance of industrial design. So do's and don'ts in case of IP. For example, I'm sorry if my presentation is visible. Okay. So our honorable Prime Minister, he said that my motto for the country's young scientists is that they invent and then they file patent application, then they produce or they means translate their IP, because technology transfer itself help in generation of revenue and which will contribute to the GDP of India as well. So it is up to you if you want to file patent or not. If you want to disclose your invention amongst the collaborators or amongst the public, or make the confidentiality of your invention and file IP first. So it is said that IPR, it acts as knowledge economy which contribute toward GDP of India. So it is always recommended to first protect your IP before publishing it, because it is always seen amongst the students or faculty, they are interested in publishing their work. But if your invention has worth, it is novel, it has inventive step, and it has industrial application and patentable subject matter, then it is advisable to first file patent application for your invention, and after that you can think of publishing your work in other journals as well, because at that time you will have evidence that you have filed patent application prior to that, and it relates to you if anybody will copy your idea. Significance of patent searches. Okay, so as you know, filing any IP, or especially in case of patent application, it is very expensive. So it is always recommended to go for novelty and patentability search for your invention. Why? To avoid reinventing of a wheel. Because if you file a patent application for your work, the first thing the IPO will see, the examiner will see if your invention is already in the public domain or not. If the same kind of technology or patent application or published patent are already in domain, then your patent application will be rejected by IPO. And all the money which you have expended or all the time, it will be wasted. And most of the students, what they do, they check their prior art on the Google patents. No, from the few hits from the Google patent software, it is not said that your invention is novel. You have to do extensive search for your invention, and you can consult any IP professional who can do extensive novelty or patentability search for your invention. So before filing any patent application, go for the novelty and patentability search to know that if the similar kind of products or technologies are already in the existing domain or not, so that if you find yes, there is similar kind of products or technology are in the public domain, then you can improvise your technology. You can check what are the gaps area in which there is need to research more. Then you will be able to fill those gaps and file your patent application according to that. Formulation of IP strategy. It is very important for any researcher to formulate proper IP strategy if they want to start their venture in future as well. See, if your origin of your invention is India, then first you have to file patent application in India itself. After filing patent application in India, you have 12-month deadline to which you can decide where you want to go. If you want to file in one country in abroad, then you can directly file. But if you are thinking of filing patent application in more than 3 or 4 countries, then it is always recommended to file through PCT, because it will save your money, your time, and of course, with the one filing documents can be used in other countries as well, except few countries like Japan and China, where you have to file translation of your patent application as well. Now, first, if you will do invention disclosure in front of any IP professional or any collaborator, then first sign NDA or any confidentiality term with them. IP professional, they will evaluate their technology. If it is a patentable subject matter, then file patent application in India. And after that, do extensive market potential search for your invention. So if your invention has market potential in other countries, and you are thinking of launching your product in other countries, then yes, it is advisable to file or protect your IP in other countries as well. Because IP portfolio, it plays very important role in commercialization of your technology. And you have spent so much time and money on your research work, and you want it to commercialize in future as well, then yes, first have a strong IP portfolio itself. And before completing this, I just want to share one example with you for the formulation of IP strategy. One of the team of inventors, they invented medical device for the surgery of cervical cancer, and they file patent application in India itself, then they realize that the market potential of this medical device is in US itself. Why? Because there is a rate of cervical cancer patients are high, and already existing products are not as good as your inventor's technology is, and moreover it is available in low price as well. So that inventors team, they file patent application in US itself, and after that they launched their product in India and US, and now they launched their business or product in India and US, and now they are earning royalty or revenue from those technologies as well. So this was all about IP, very basics of IP. Thank you so much.
Thank you, Rima ma'am.
Yeah.
Yeah, if a participants have the question, they can post on the QA section. In the meanwhile, we will check and let you know. If someone has the question, they can post their question in the QA section. No question is there, ma'am. Thank you, ma'am, for your nice speech on the patentability criteria and how the patents can be done. Really, these things will help the academician to project themselves as a good researchers. And thank you, ma'am. And our next talk will be given by Pragati,
so much.
Pragati Agrawal, ma'am. This will start.
Hello.
Hello.
Hi. A very good yeah. Thank you so much. So a very good afternoon to one and all present here. I'm Pragati Agarwal. I'm working as a senior project officer with Innovation Technology Transfer Office at FITT IIT Delhi, and I handle intellectual property. I manage intellectual property. So in the few seconds, I will be sharing my screen. So please confirm if it is visible. Mr. Mehto, I'm not able to share it. Could you please?
Okay, ma'am. Just a minute.
Yeah, the access is denied.
Vinit, sir.
Salish. Sir, we have given
Yes.
the presenter right now.
Okay, okay.
Yeah,
Ma'am,
thank you so much.
Present.
Thank you so much. So I hope my slides are visible to all of you. If anyone can confirm, it would be great.
It is visible, ma'am.
Thank you so much. So I will be discussing about what is or any unintentional mistakes can harm your invention, or how you may kill your invention despite of being original. So being an first thought that crosses our mind would be, let's publish the hard work, or let's talk about it at some research work or some. So can such scenarios harm your invention? So we will be finding answers to such questions. So to begin with, what is invention? So as my colleague Ms. Rima has already given us a pool of information regarding what is invention and what cannot be considered as an invention. So I will be giving a brief about it just to connect the dots for the audience. So a new product or a process that is an inventive step and is capable of industrial application is considered as an invention. That suggests that the invention, it can be considered as an invention. So the first and the very essential parameter is of novelty. that is the new. So the subject matter of the invention should not be fall into the public domain or not form part of the state of the art. So until your invention is just known by you, like the only person you know about the invention you have made, it contributes to the novel element. It our invention novel, and since novel assessed globally, and that of global patent. So, and as told by my colleague Ms. Rima, the patent rights, though the patent or the IP rights are territorial in nature, but the novelty is not. So, it is. However, any inventor or innovator may for IP rights and may secure IP rights by internationally also by entering into the respective country. The second parameter is the inventor step. How an inventor assesses that if the invention step, so that could be assessed by advancement over the background art, or maybe by differentiating it over the existing prior arts and solutions in terms of economic significance, or maybe both. So by economic significance, I mean, for say you have invented something that is more cheaper than the available solutions. So in that case, that would comply with the economic significance parameters, and that would actually make your invention as technically advanced over the already existing solutions in the market. The next parameter is industrial applicability. So the invention should be able to the invention which has been done by any inventor should be able to made or produced, and it should be of use in some kind of industry. So that accounts to industrial applicability. Why it is very important, or why securing IP rights is so much of importance. So as discussed previously by my colleague, since IP tangible assets, and we all know how having those tangible assets make us feel secure. For say maybe in the terms of gold, and maybe in the terms of a piece of land and any property. So those tangible assets make us feel secure. Similarly, even the IP rights, or even securing the IP rights, are of utmost importance. They help us set it. They can be sold, they can be licensed. They basically contribute towards revenue stream, to generate revenue out of the hard-earned invention results. So, and as an inventor, we might what the little component even can generate an IP out of the invention. So we need to find such novelty, such newness in to secure IP rights. Lose IP rights, even after owning the invention. And the answer lies in the novelty. And by compromising the novelty, that is the newness of the invention, may kill our invention. Displaying our invention or disclosing it publicly, we actually move farther from securing IP rights. So basically, novelty is compromised when any public disclosure, and it does not even matter whether someone has that disclosed knowledge or not. In case you have disclosed it, the novelty has been compromised. Disclosure, even a simple presentation in a closed room with hardly a person, you may put the novelty of your invention at stake. So I have listed few disclosure, different disclosure by which the novelty can be compromised. So these are class presentations, or publishing your data, or maybe even presenting it presenting it at some research talks, and even if we are putting our invention to commercialization before obtaining or before securing the priority and IP rights, we are actually subjected to lose the novel element in our invention. Is whom to trust. Like many inventor, like they want to consider, or they want to take some help from other person who is actually expert in that area, maybe to solve some issue, and that's all. But is it even safe to disclose your invention? It might have not reached the final look, but still. So in case there is even a dire urgency to discuss your invention with anyone, you need to confidentiality agreement prior you disclose your invention. The next question would be for a patent before publishing the invention, and the answer is yes, absolutely. So always make it a thumb rule: file before publish, because there are so many incidents where it has made a publication out of innocence before filing the patent application, or any or for applying any IP registration, would still be considered as a prior art, and it might impact the novelty of your invention. The inventor's own publication would even result, and the patent rights might get rejected. So before publishing, the inventor must go for filing a patent application. So we have heard this many times, like if you ever invent something original and useful, so one of the finest and the solid piece of advice, make sure you get it patented, or make sure you secure IP rights over your original piece of work. And this is actually very true. So in the upcoming slides, I have listed few examples where inventions are not IP protected. That is, the inventor or declined to file IP for it, or maybe out of innocence he has not filed any IP over his invention. So the first one is the emoticons. So as we are largely using such emoticons in our daily chats and different discussions with our colleagues, maybe with our family members and all. So the first smile call, so it was first designed by an American artist, Harvey Ball. Assigned this task to boost the morale at an insurance company, but outside of the office. Also, Mr. Ball, he declined to register a copyright. Therefore, he was paid only for the original design. In case he is gone for IP protection, he made like more money, at least more than what he was paid for his design. The idea of scraping a little stick to generate fire is around forever. But these were actually invented by John 24. So Walker came with a sulfur paste that sparked when scraped against a rough surface. So, however, concerned with the safety of the flame, so he refused to file a patent application over his invention. So billions of dollars in profit was made out of it, but he didn't see a dime. In case he had action, he might be a billionaire by now. Next example is of the transaction cards. Not transaction card, literally. These are the magnetic stripes. So earlier, stores had to check the against a huge list of fraud cards, and that too manually. So Ron idea to invent the magnetic stripe. So what he did, he is used in a reel-to-reel tape recorder and affixed it to the back of a card, and then he number on it and created a scanner to compare that data. Actually computerized all the efforts. So, but again, he never patented the magnetic stripe idea. But it was quickly adopted by pretty much, and we too are very familiar with this magnetic stripes which are present at the back of our cards, and then making our lives so easier in this world. So interesting example is of polio vaccine. So the story, when Salk came up with the vaccine to eradicate the polio and released it to the world in 1955, some news reporter, Edward, asked him who patent belongs to, like who the IP rights belongs to over this vaccine. So Salk said, the people, I would say. So there were, so he didn't go for patent. He didn't go for an IP filing or IP registration. So because he wanted the global health crisis of polio to be abated, but so the common wisdom says that Salk actually refused the patent because he wanted the global health crisis of polio to be abated. But it is more of the opinion that maybe the Salk Institute had explored the possibility that the application might get rejected because it was there in the public domain before. Anyhow, he actually declined and refused to file the patent over the vaccine. The next example is a World Wide Web. Sir Lee believed or the internet should be freely available to the masses. And therefore, he made a very conscious decision not to accept the royalties. And maybe because of his charity, we are using the internet so frequently and with so much of comfort that even in this pandemic days, we are actually exposed to gaining and sharing of knowledge on a regular basis. So these were the few inventors who actually didn't create money out of their invention. What if an inventor discloses, maybe out of innocence or any other reason maybe? So there are few remedies which are provided by Indian patent law. So to begin with, I would like to start with what it would help to clear the upcoming slides to have a better clarity in the upcoming slides. So what is anticipation? So in terms of Indian patent, anticipation refers to any prior disclosure either by an inventor himself or by any other person. So in case your invention is already out in the public or has already become part of public domain and public has an access to it, then your invention would appear as an anticipate. So to overcome such, the Indian patent law has issued few remedies. So we will be discussing about these in detail in the upcoming slides. So the first one is by previous publication. So how a previous can make your invention appear anticipate. So for say you have published discussed your invention with a friend of yours, a subject knowledge over the invention which you have discussed with him, and what he does is he published your invention in some journal or maybe as an article or maybe as a presentation. So he's actually or publishing your invention, but the catch is without your consent. So this is the scenario: if someone has obtained your invention or your idea invention and he is publishing that invention, so in that case your invention does not contribute towards that is, your invention remains novel. The novelty of your invention is intact, but the inventor himself published that he applied for the patent application as soon as he came to know about such publication from so and so person. Anticipation is by previous communication to the government. So for the purpose of investigation, maybe for the purpose of merits and demerits. In case being an inventor, you are communicating your invention to government or any person authorized by the government. In that case also, it does not account for anticipation. So we can consider one example for say, if the inventor has applied for some grant or some fellowship, and he actually discloses the idea of his invention, and he has not filed or he has not secured any IP rights over that idea. So in that case also, it will contribute to anticipation and the novelty of your invention would be intact. So the next mode of anticipation is through public display. It is actually a very interesting section. So it involves for say there is an has been organized under the provisions of the central government. And in case you are presenting your invention in such an exhibition, then it won't be considered as an anticipation. Secondly, in case the invention in that exhibition is published as a exhibition, in that case also it won't contribute to anticipation. That is, your invention would be novel in case you have presented in any such exhibition. Thirdly, if someone is attending that exhibition, for example, and you have put your invention to display, and he being the subject expert in that area, he gains knowledge and he gains insights into your invention, and after gaining that insights after the exhibition, but again the catch is without the consent of yours. So in that case also, the invention and the novelty of your invention won't be compromised. Further, in case you have disclosed your invention or presented your invention before a learned society, you have published your invention in the transaction of such society. So in that case also it won't contribute to anticipation, but there is a catch here. That is, the term learned society, it has not been defined by it has not been defined under the Indian Patents Act. So such publications are completely assessed by the controller, and he may exercise his discretionary powers to coming to the final result, any final decision over the novelty aspect of your invention. Also, again, for any such public display been allowed under the Indian Patents Act, and that is up to 12 months from aforementioned public display. For say, if you have displayed your invention or disclosed your invention by any such mode of disclosure for say today. So within the 12 months, you need to file a patent application, or you need to apply for a for a patent rights in order to secure IP rights and to prevent labeling of your claimed invention as an anticipation. Section is anticipation by public voting. So to benefit from this application must be filed again within a grace period of after the invention has publicly worked out. So publicly worked out means for the reason of some trials or some experiments considering the nature of the invention. So that public workings and disclosures are allowed under the Indian Patent Act, but the inventor needs to file and needs to comply with filing of patent application within the 12 months. The window period is. So the next section is anticipation by use in publication after a provisional specification. Invention has been put to use and has been published after the provisional application has been filed, then the filing of complete specification would not account to anticipation. So in case you have filed a provisional specification, you have already secured a priority date by filing a provisional application, then filing a complete specification won't harm the novelty of your invention. So it is always advisable for inventors to patent or to apply for patent applications for their inventions, as its benefits are manifold, and the best have is you actually own your invention. So talking about like how anticipation works. So in the US also there is a grace period which is allowed for for any mistaken or accidental in case it has taken place. But Europe and Japan has strict window period of 6 months, and they do not allow to for the filing of such applications once the window period is crossed. And we all know a secret shared is not a secret anymore. So why risk our inventions? Why to risk the hard work we have hard done for so many years? That true prevention is not waiting for bad things to happen, rather preventing things from happening in the first place, as it is said by John McPherson. Ideally, one should file a patent application before publicly disclosing the invention. So there are very there are very many incidents which happen, I've encountered so many incidents. For say, there was one inventor who actually, has invented something very original, but unfortunately, he put that to commercialization. He was distributing it through to the business partners. So what happened? He came to us saying that his idea of invention is very novel, very unique, and it is it is technically advanced, and it has market potential as well. So the first thought that crosses our mind is no, your invention is not novel anymore. Though it might be inventive, it might have it surely has the market potential, but since it has put to commercialization, that means it in the public domain, it is a part of prior art, background arts. So novelty has been compromised. However, if a public disclosure is made before filing a patent application, then one can still contemplate patent application in light of the provisions just discussed now. Still, it is always recommended, file before publish. So, even if you are of doubt that whether the invention is or not, so you may go for few novelty searches or patentability assessment, as is also discussed by my colleague Ms. Rima. So you may discuss out the things with IP professional and may ask him to carry those novelty searches. So in case your invention comes out to be novel, comes out to be patentable, so you must go for filing a patent application, because it hardly takes, hardly takes few days to complete the process of filing. But then once it is in public domain, then fighting for the owner rights is really difficult. So I would just I'm just about to conclude the whole presentation. In case of any queries regarding any novelty searches or patentability assessment or any IP advisory services, so you may reach us at queries.ittr.outlook.com.
Thank you, Pragati ma'am. And if someone has any query, they can post in the QA section. Vinit sir?
Yeah, I'm searching.
We are
I'm
looking at
searching.
it. Just a moment.
Yeah.
I don't find any of them, but my network is
Trademark
also
is given for 10
I
years.
request Ravi to say it.
So after
Yeah.
10 years, is it to be updated or renewed, or trademark can be changed?
Am I
Sorry,
audible? You can renew the trademark after the tenure of 10 years.
Okay. I don't see any further
I have a
questions.
question. Yeah, I have a question, madam. Suppose for a book, a publisher has a right for 20 years, for 16 years. Is it possible to extend the copyrights of the book publishing, or it is always expired?
No. Copyright is like the lifespan of an author, and after the death of author, it is till 60 years.
We see some of the books will come out in the open, anybody can publish after 2 years or so. Okay, I think I might be missing it in duration.
sorry.
Sometimes we see, madam, like some books which were published by only a single publisher for long, maybe 20 years or something. Suddenly, everybody else has started publishing. So, is it not extendable, or it just expires after some time? Or publisher sees no value in copyright?
The copyright for a book, for example, for actually these are the rights of creator. like, okay, but if publishing house has given money to that person who have written that book, then the rights are with publishing house, because it is always written in the book that all the copyrights are reserved to dash and dash publication. So it depends upon them, because they must be paying royalty to the author of that book.
Yeah, definitely.
Yes. So it is up to them. Maybe they want to improvise the content and then again they can republish the book. This can happen in that scenario. Otherwise, the copyrights are, it is the entire lifespan of the author, and after the death of author, it is 60 years.
Thank you.
There's
You're
another,
welcome.
there are some questions. Can some books or novel be written under patent?
No. Books, these are not patentable subject matter. Patent is something different. It is all about invention, and it should have criteria of novelty, inventive stuff, and industrial applicability. Whereas all the literary work, because books, it comes under the literary work and it is copyrightable subject matter.
Another question, are new softwares covered under patents?
No, software are not patentable as per se, but yes, if because it is the coding and the algorithm, it comes under copyrightable subject matter. But in case somebody has joined copyright with hardware, for example, now all the medical devices are that are available in digital form. In that case, the inventor has applied software in the medical device. In that case, it is patentable subject matter, but software per se is not patentable, and it is debatable as well. It the coding and the algorithm, it comes under copyright law.
There's another question, if someone is having only an idea, is not able to demonstrate, so can
Okay.
it go for patent application?
No, sir, because yes, you can do one thing. You have idea. You can go to the lab and see if it is in future, if that idea is workable or not, if functional or not. Because idea per se, you can't file a patent application for that. You must have something, like any prototype or something. Or yes, if you have something like that idea, but yes, you can in future you can file provisional patent application, and down the line you can further develop your technology and file complete specification. But if it has no any, it is idea per se and has no any application or utility, then it cannot be patentable.
There's another question, can we get a patent or copyright for a old research paper which was published 8 or 10 years back?
No, sir, never.
Okay.
Because in patent, I already said that only the one publication can kill the novelty of your invention. And my colleague Pragati told you about the anticipation law section, which are quoted in Indian Patent Act 1970. There is a timeline of 12 months if you have published your data or display your idea or communicate your idea to government. In that case, it is not the killing of your invention.
There's one more question.
Otherwise, yes.
If we want to do copyright published paper, do we have to get permission from research paper publishers also?
Sorry, if you want to
do copyright published paper,
okay,
do we have to get permission from research paper publishers also?
okay, this question is actually see, I can give you one example. When I'm writing my thesis or I'm preparing my PPT, I will give due credit to the author or to the scientist from where I'm taking the content. Likewise, this happen. The creator of, if you are using anyone's work, then you have to take, either you can take permission from them, if you are doing any revenue generating work, or if you are in education system, then you have to give due credit to the author or the scientist, or but not the publishing house, I can't say. Because it is always said you can use the copyrightable material for education purpose, but the condition is that you have to give due credit to the creator of that work. And I think everybody who is writing their thesis, they write about from where they have taken these lines, or what, who was the author, and in which journal it was published. So we all researchers used to give this credit to the creator of that work.
Pragati ma'am, another question is there from the participant. So he is asking that if someone is performing some project on Arduino, and if it is some novelty on it, can it be get protected or patented?
Pragati, are you there?
So sorry, I've been on mute since Ms. Reema has been answering the questions. Yeah, so could you please repeat the question?
One participant has asked that if he is performing some Arduino based project, and if it is some novelty, so can it be get protected or patented?
Yeah, so he might consider for applying a patent application out of on that particular invention. But before that, it is always recommended before applying for any for any invention as a patent application, he must check the novelty and the patentability assessment. So in case the invention comes out really novel and it comes out to be patentable, then he should go for filing the same.
Another question is still there. In order to get the exception or anticipation, is the onus on the inventor to prove it? He has to prove it.
Yeah, because he needs to prove that the invention which has been published or which has been disclosed publicly was actually obtained from it, and it was obtained without his consent, and he has actually no idea that it has been published by that person. So yes.
Okay, ma'am. No questions are there in the Q&A box. Another question is there, to get the patent, how someone should approach? He has to need, might be his,
Sorry?
one participant is asking to get a patent, how he should approach some agent or a patent attorney.
Yeah, so we like he may contact even us also, so we may connect him to the law firms, or we may just help the candidate assess the novelty and patentability. So he may reach out to us as well.
Okay.
Yes, please.
Another question is, ma'am, which cases are not considered a copyright infringement?
Can you repeat the question?
Which cases are not considered a copyright infringement?
Okay, for if you are using somebody's material, literary work for education purpose, and you are giving due credit to that person, in that case, it is not copyrightable infringement. For example, if I am quoting some examples from any book or any scientist, I'm just quoting their work for the purpose of teaching my student. Okay, this is purpose of training the use. In that case, it is not the infringement of copyright. Thank you.
Okay, and no other questions are there in the queue box?
Yeah, can I have one, madam? Vinit Saula here. Yeah. We are just anxious to know, like, about universal impact of a patent. Like one patent is in US, patented in US. Another is patented in India. Wise two country, if we have a WTO or GATT, whatever, are these two patents applicable to other countries also? Each other countries?
Sir, can you please, your voice is breaking. Can you please repeat the question? Or
Sure. I have one patent in India by person one.
Okay.
And one patent in US.
Okay.
By person two. What is WTO DOTT like agreement? Whether these two patents are applicable in a cross country?
Okay, if I'm correct in understanding your question, you are saying you have filed patent application in India and US. If it is applicable in other countries or not, is it so?
Yeah, separately, my question was separately, maybe it can be generalized. Patent one in India and patent two in US, are they applicable in cross countries?
Yes. If you have, yes, there is timeline in which you have, for example, your patent application first you file in India. Okay. The same patent application you can file worldwide as well through PCT or other route patent. This is Paris Convention. Through PCT, if you file patent application in other countries, the document which you have filed during the first filing, these are eligible for filing in other countries as well.
Maybe part B is like a US patent.
Okay.
Person is getting some patent in US.
Yes.
Does it have two domains, like only for US and the whole world?
Okay. Yes. If any person who is from US itself have filed first filing in US, okay, and then he decided to go for national phase filing, yes, the same patent application can be filed through PCT from US to other countries as well. And if you want to file, yes, there is other way around as well. If you are in India, as I mentioned in my slides as well, if the origin of your invention in India, then first file your application in India itself. But yes, if you want to file your patent application in abroad directly, and you are not interested to file your application in India, then you have to take permission from Indian Patent Office. And this provision is also available in India with Indian patent law.
So what I
Thank
understand
you.
is these two processes are different.
Yes.
Thank you. Thank you.
Thank you.
Thank you, madam.
Thank you.
Vinit, sir. Can we stop it? We shall meet at 4:30.
I will request Ravi to proceed.
Okay.
Since Tripta madam is here, can we make it a bit sooner, like 4:15?
Yes, sir.
If this is fine with everybody.
Yeah.
It's half an hour break.
Half an hour break is there.
Madam.
Can we start at 4:15?
Ravi, you can confirm from both speakers. If we prepone it by 15 minutes, are they okay?
Hello.
After Tata madam, we have to ask Satish also.
Sir, the question and answer session may actually means this thing may go
Okay.
start with like
Sure.
5 minutes. Okay, 5 minutes. I'm just reviewing. Okay, thank you.
So you announce 4:15 then?
Sir, sir, ये 4:30 टाइम था. Somehow, I'll just okay. I'll just start. I'll speak with them. Hello.
Tripta madam,
Yes, sir. How are you doing?
I'm fine, madam. Will you be able to start at 4:15, madam?
4:15. Yeah, I can start in another 5-10 minutes if that's okay with you.
Actually, we have been sitting through for 2 sessions, so we were thinking about a half an hour break. And
Not
we'll
a problem. Actually, right. Actually, I was in a meeting. Fair enough. 4:15 is okay to me.
Yeah, madam.
Okay,
Actually, madam, what we have planned is we take 2 hours and a gap of
Right.
half an hour. Only
Right.
thing is this finished earlier today. So, okay, thank you. 4:15.
4:15. I'll see you all. Thank you.
Okay, next session would be starting at 4:15 p.m. So you can really have a break again today.
Thank you so much. Thank you.
Thank you so much.
Abhi, who has the last session? Is it Satish?
Last session would be with Satish sir.
Satish, sir.
So yeah, okay. So we should ask him whether he can come 15 minutes earlier. In case we.
Okay, sir. I'll talk to him, sir. I'll talk to him.
Sure. Thank you.
Okay, sir. Thank you, sir.